Can I see the file on Christopher Andrade? All right, Vashon, why is Christopher Andrade on the docket? Ah, yes. All right, we'll have them bring him out. Yes, please. Thank you. Hmm? Yes.
Got the wrong number yesterday.
Okay. Mhm. Mr. Cox? Yes, please.
Very cool. Judge, I do think we need to run down and make a large payment.
Okay. All righty. All right, thank you. All right. Mr. Cabanas,
Yes, sir.
on Clara Rascon, where are you on discovery?
Judge, I just wanted to say, they handed me a copy of the CPS records,
Okay,
so they thought them in their board, after morning.
okay.
Now that I have this CPS record, I
Mhm.
should have everything else.
All right, and state, had you already tendered an offer in this case? Okay. When are you coming back on your other case?
19.
All right, so the 19th of December? All right, the 23rd, January. Yeah, okay. All right, we're coming back on January 23rd, stating you need to be prepared to tender an offer at that time. All right, is there anything else? All right, Deputy, you can counsel, unless you need to speak to him, we can counsel Clara Stone. Okay, okay, all right, thank you. Yes. All right. Second. Oh, yeah, sorry. No, it's for the state to tender an offer. You can put it down as discussed. Yes. Well, it's not a plea deadline date because the state hasn't tendered their offer yet. If it needs to be put in the system, you can put it as discovery. Oh, I'm glad you didn't fall. Sure.
Well, they use it for their product.
You're welcome.
Thank you.
Mhm.
Yeah, okay.
All right, is there a reason Christopher Gonzalez isn't dressed? Christopher Lee Gonzalez, is that what he's wearing for trial today? Okay. Why isn't he dressed? Counsel, is there a reason he doesn't have any clothes? Yes, I mean, does he want to go to trial in orange? Sure. Good afternoon. So you're scheduled for jury trial today, but obviously it wouldn't be fair for you to go to trial dressed in orange. So your attorney is going to get clothing for you. Um, he says this evening, and we're going to bring you back for jury trial tomorrow. You understand? So it will be going to trial. Your plea deadline date has expired. The court will not accept any plea bargain agreements after today without good cause. Otherwise, you would have to plea open to the court. Do you understand? Yes. So with that being said, unless you all have reached agreement, you're going back to custody for jury trial. You're welcome. All right, he's coming back tomorrow. Ricardo Garcia. All right, you're up for jury trial.
Your Honor, I'm not ready for, to continue. I put a motion to dismiss and affect the counsel. And I think I have brought it up the last time I came, of court, that I wasn't aware that I was indicted, and I was handed an indictment, but that day, and like, the last time that I came out, I feel like I wasn't given sufficient time to prepare. To any objection to the indictment. I wanted to go over the indictment and look over it. And object.
All right, you can go back in the box
I
and
did.
look over the indictment with your attorney, but let me explain something to you. Your attorney went to law school. If your attorney feels as though there's nothing wrong with the indictment, then they're not going to file any motions.
I understand.
In
I
regards to
understand that I didn't go to law school, but
No, I'm just saying
Yeah.
that this is an attorney.
yeah,
If they've gone over the indictment with you and they say there's not an issue with the indictment,
I understand.
then they're not gonna file any motions.
Well,
as it
he
relates to
hasn't
the
gone over the indictment with me. And
All
that,
right, sit over in the box. He'll go over the indictment with you. All right,
so I can't, I don't have no confidence in.
all right. So what you can do is you can sit in the box with your attorney. Your attorney will go over the indictment with you.
Okay.
Thank you.
Judge, there's also the mental health issue that I mentioned earlier. I've learned that he's not taking his medications
Okay,
and so I'd like to file a motion for mental health eval.
all right. Who's the prosecutor on Ricardo Garcia? Defense counsel is requesting a competency evaluation. So,
Sorry to interrupt you. I conferred with defense counsel earlier and I have no objection to his motion.
all right, so he's gonna go back. The court is legally bound to give a competency evaluation when it's requested. So recall this back and we'll put it for jury trial. We'll put it for January 27th and see if the competency evaluation is completed. If it is, that's the date for your jury trial date.
Thank you, Judge.
All right, thank you.
May I be excused?
You want to tell your client?
Yes, Judge, I would. Right.
Sure.
I just want to say for the record, I understood what you just told me, and we had the opportunity to go over the indictment when I last came to court, when I found out I was indicted, and I was ushered out, and he explained to me that he was gonna come visit me. I've been incarcerated for 10 months already, and I have not had one visit from this man or had any written correspondence from him. He's given me two different numbers that I haven't been able to get a hold of. He told me he was gonna be out of town the last time that we talked for the holidays. So that's the reason why I figured he didn't answer the phone now. You asked him to go down and sit down with me over this indictment,
Mhm.
and he pulled up that mental health issue without coming to me and asking me, hey, you know what, I'm gonna ask for this motion to go in. Motion that I would have wanted to him to put in, we haven't discussed or gone over this indictment, and I've been indicted since August 15th. I wasn't known, this wasn't brought up to me till October. And he still hasn't gone over this indictment with me or discovery, so,
All right, so here's the
Okay.
thing. I'm gonna take this process with you step by step.
okay,
If there's something that I tell you that you don't understand, just let me know. Okay? So this is based upon my
yes,
experience
ma'am.
as a defense attorney.
Okay,
Sometimes, as a defense attorney, you don't know when your client has been indicted. And let me just tell you why. The reason why you don't know is because you're not his only client.
Yeah.
Sometimes you have attorneys who have 12 and 15 clients, sometimes more. So they don't go on your case and they don't look up every single day to see if you're been indicted.
Okay.
So sometimes what ends up happening is how they know you've been indicted is they receive a letter in the mail or card in the mail saying this case is set for today,
okay,
which means that the case has been indicted.
okay,
The prosecutor, they don't pick up the phone and call
Yeah.
your attorney and say, hey, just so you know, I'm taking your client's case to the grand jury tomorrow.
okay,
And then if the grand jury says, yes, there's enough evidence to hold them over for trial and we're going to indict it, the prosecutor normally doesn't pick up the phone and call every attorney that's on that list and say, hey, just to let you know, the grand jury indicted your client today. So sometimes the first time that a defense attorney will know, and this is not saying anything bad about the defense attorney, this is just the way it works. Sometimes they don't know that you've been indicted until they get a notice telling them they need to be in court because your court is set that day. And let me just tell you, with indicted cases, I won't know you've been indicted until it gets set on the docket.
Okay.
And I don't set it on the docket. It's done automatically through the computer system. So that's why he can't come to you and say, oh, by the way, you've been indicted. He knows you've been indicted when he's ordered to be in court. So he's here today, right? Now, the next step in the process in this court, I make sure everybody has all their discovery, and then I require the state to tender an offer. Once the state tenders an offer, then your attorney will let you know what the offer is. You can either accept it or reject it. I'm here all day. So if you don't want to accept it, that is fine. Then you'll be scheduled for a jury trial. So today is your jury trial date. Now, what holds up a jury trial? Sometimes maybe there's some new discovery that's been given. I don't have the defense attorney's requests continuances normally for that because it's not really their fault.
No.
Now, if your attorney thinks that there are some mental health issues, what do I mean by mental health issues? They feel as though you don't understand what you're charged with, the consequences of the decisions you're making related to that charge, or if they see that maybe at the jail, it says that you've been on mental health medication, they may say, maybe this person isn't competent. And once an attorney legally comes to the court and says, I believe this person needs to be evaluated to see if they're competent to stand trial, then that stops everything. And then what I have to do legally is I have to send notices out, send an order out saying, I want this person evaluated for competency. Because it wouldn't be fair for an attorney to go to trial with the client and that client doesn't know the consequences of the decision he's making. And as someone who's accused of a crime, you have certain rights. You can make a
Exactly.
decision on whether you want to testify or not. That's not your attorney's decision. Your attorney may advise you, but that's your decision. You can make a decision on whether you want to enter into a plea agreement or not. You can make a decision on whether or not you want to waive jury trial, but the waiver of the jury trial, the state has to agree to it as well. So your attorney has stated to the court that he believes there may be some competency issues here. So with that being said, legally, I must, and I will have a doctor come see you to evaluate you. And then we're going to come back, and we're coming back on January 27th because that's the length of time it's taking to get evaluations done. I don't know if your evaluation will be completed by that time or not, but we will see.
I partially understand. everything that you explained
right,
to me.
what
I
do you
wanna
not
say
understand?
thank you.
Let me know.
What I don't understand is if I have certain rights, the way you expressed and his obligation to go over those indictments with me when he gets notice of it. Okay, so this is the second time that I've seen him. Now it's been 10 months. We could have that's more than enough time, I feel. And 30, 45, 40 days since he got the indictment should be sufficient. He still hasn't gone through it with me.
Okay.
We've been sitting
Well,
there.
I tell you
So
what,
that's basically why I'm bringing up my loss of confidence in him and why I submitted the
Mr.
dismissal
Hardy.
in case I do lose in trial.
All right, Mr. Hardy, will you go over the indictment with him? I know that you've already said that you want a competency evaluation done, which will be done. But,
I'd be happy to, Judge.
all right, so he's gonna go over the indictment with you today. Listen to him, okay?
I will.
And then we're gonna bring you back on January 27th.
Okay, when will we go over, if I still feel the same way, over the
I'm always willing to hear that.
the motion to dismiss and for the reason why I gave.
I'm always willing to hear
Okay.
that, but what I can tell you is normally
Thank you.
what needs to happen is if you want a different attorney,
Yeah.
you have to hire one.
Yeah.
But he's willing to go over the indictment with you again, so he will do that.
Okay.
All right, thank you.
Thank you, Judge.
You're welcome. You're welcome. Who's here on Aldo Solis? What is happening with Mr. Solis?
Ma'am.
All right, you all have 10 more minutes.
Thank you.
I'm sorry, what?
Still no curio.
Ah, okay. I was like, curious.
Yeah.
Can I see the file on Curio, please?
Yes, ma'am.
That'll be that.
All right, state on Kevin Curio, the failure to stop and render aid.
Judge, I
Yes. Oh, Justin Burke. Andrew Elderman.
Mr. Elderman? They're good to go on county court.
Eagleman and Robin Roll.
You want to hear something hilarious? When I was in the DA's office, everyone was calling the prosecutor who was sitting in that court. They were calling her, I think it's Alex Andrea, right? I think that, I can't remember her name now. The reason why I cannot remember her name, because everybody was calling her Alexandria or either something else, or Alexandra, right? So it turns out people have been calling her name the wrong name forever. Now, mind you, it's stuck in my mind, the wrong name. And so all of a sudden, out of the blue, she tells somebody that's not her name. I said, why do you tell anybody beforehand?
Yeah.
I said, so I had to write it down on a piece of paper to try to get it in my mind that this is the correct name. Oh, are you ready on Andrade?
Not
No.
yet, I'm
Okay.
sorry.
Bruce.
Yes. Thank you. The clerk and 14 is most gracious.
Gracious and grateful.
Grateful. Most gracious of your.
What's your boss?
All right, what is happening with Aldous?
We have an agreement now.
All right.
And then she, wait, can I take that? It's scratch paper.
Aldous is gonna be a plea.
My lips are, I put on some.
Are you already on Cox?
There you are.
Yes, Carolyn.
All right, can I see the file on Cox, please?
That's fair.
All right, so what is the decision on Mr. Cox?
Your Honor, I believe the state and I both had the opportunity to speak to the complaining witness, in exchange for complete upfront restitution. She agreed for the case to be dismissed up through a TIC and then to continue on probation. I don't believe there's anything else that you have.
That's it, Your Honor.
Well, on the motions to revoke, we're proceeding on those, correct?
We have agreed to plea on 17 and 19 on these two different, motions
All right.
to continue on 2 years, extend for 3 years.
All right, court is calling 2021 CR 4964, 2018 CR 11550, state versus, I'm sorry, yes, state versus Michael H. Cox II. That party is announced for the record. State,
Andrew Harris Edelman?
defense.
Austin Hagy for Mr. Cox.
And are you Mr. Cox?
Yes, ma'am.
Are you the same Michael H. Cox II who was placed on deferred adjudication in 2021 CR 4964 for the offense of theft, 30,000 to $150,000 on December 6, 2021 for a period of 4 years? And the same Michael H. Cox II who was placed on deferred adjudication in 2018 CR 11550 for the offense of theft, $2,500 to $30,000 on January 14, 2020 for a period of 3 years. Is that you?
Yes.
State, are you proceeding on the same allegation in each motion?
Yes and no, Your Honor. The substance is the same for each, but they have different numbers.
Right.
So in 2021 CR 4964, on or about the 6th day of February 2024 in Bear County, Texas, the defendant, Michael H. Cox II, did then and there fail to register for or attend a theft program level 2 with the approved agency in violation of condition number 17.
How do you plead to that? True or not true?
State waives the remaining violation allegations, Your Honor.
Any objection?
No, Your Honor.
In 2018 CR 11550, on or about the 6th day of February 2024 in Bear County, Texas, the defendant, Michael H. Cox II, did then and there fail to register for or attend a theft program level 2 with the approved agency in violation of condition number 19.
How do you plead to that? True or not true?
State waives the remaining violation allegations, Your Honor.
Without any objection?
Yes, Your Honor, no objection.
All right, did you understand by pleading true to violation of condition number 17 and cause number ending in 64, court could find you guilty, grant the motion, and sentence you up to 10 years in the prison and up to a $10,000 fine? Knowing that, do you still wish to plead true to violation of condition 17?
Yes, ma'am.
Court will find violation of condition number 17 true, and in cause number 2018 CR 11550, did you understand by pleading true to violation of condition number 19? Court could find it true, grant the motion, find you guilty, sentence you up to 2 years in the state jail facility and up to $10,000 fine? Knowing that, do you still wish to plead true to violation of condition 19?
Yes.
Court will find violation of condition number 19 true. And it is the court's understanding that the case that he paid restitution on, that was just some case that had been floating
It
out
was
there.
at large, Your Honor.
Okay.
Yeah.
All right, is there a proposed agreement?
Yes, Your Honor, in each case to extend probation for 24 months with all conditions in effect.
All right, probation, and the cause number ended in 11550. Is there a restitution amount that's currently due?
Yes, there is a balance, there is an amount due, he is currently making payments on that.
All right, the court will deny the motion in that cause number. Alter and amend conditions to extend for 2 years. Ah. There's an issue with regards. How long are you asking for an extension?
Judge, we're asking for 24 months on each case. And, we do realize that these cases already expired.
Mhm. With regards to this case, he can be terminated unsat, and the restitution amount can be transferred to the other case.
I don't have opposition to that, the state does.
That's what the court mandates.
All right. Any objection from the state?
No, Your Honor.
All right, what is the amount that's due in cause number 2018 CR 11550?
$7,836.
All right, defense, do you agree that that's the amount due?
That is the amount that I have seen, Your Honor. I do agree that that would be the amount.
And is the complainant Beverly Ahnee, Ahnee?
Yes, Your Honor.
1 second, Judge. That is correct, Beverly on.
All right. So any objection from either side to the court terminating him unsatisfactorily in that cause number and transferring the restitution amount to this cause number?
No, Your Honor. No objection from the defense.
Not from the state, Your Honor.
All right. Then the court is going to terminate him unsat in that cause number. And in cause number 2021 CR 4964, the court is going to deny the motion to alter and amend conditions to extend for 2 years. And there's to be restitution to Beverly Ahnee in the amount of $7,836. And probation, when do you want him to sign up for this class?
Is that court start
Yes.
by the end of January?
All right, you're to enroll in the theft course by January 30th, 2025. Do you understand?
I
Is-
believe I have the certificate. I just.
All right, is there anything else from either side?
Yes,
No,
Your Honor. If I may.
Yes. You're welcome. All right, you need to make sure you pay this restitution, you understand? And make sure you sign up for that course. Otherwise, another motion to revoke is going to be filed.
Yes, ma'am.
All right, good luck to you.
Yes, ma'am.
Thank you, Your Honor.
You're welcome.
May I be excused, Your Honor?
Yes.
Thank you.
Judge, would like to file on that case.
No, I don't need it. I'm just going to put it in the system.
This judge.
Here you are.
Thank you, ma'am.
You're welcome. And that dismissal was in 008018.
Yes, ma'am.
All right, thank you. Sure. Yes.
she wants to speak to her immigration attorney or an immigration attorney. I was gonna see if the guy at the MAC office could come over, but do you know his name? Cause I think he's in the building, He's super nice. Well, Mac has an officer who manages to sign counsel.
They're in the.
And he- I think his name, I just saw him here earlier. I wish I could go.
All right.
Who's on? I can text Forrest. We'll make a call.
All right, we're gonna start tomorrow at 9:30. So y'all need to be here exactly at 9:30. We'll do jury selection and go straight into testimony.
Your Honor, there is a matter we'd like to raise. I know that we brought this up earlier, but I hadn't had a chance to really confer with Mr. Liao. You have a copy of that indictment? There was an indictment which was given it to us this morning, which is a new indictment for Mr. Guzman, which we hadn't seen until now. And they have given us an offer. And so we've done no discovery on it, seen no police reports, know nothing about it, except that the date of this alleged offense was before the date of this case, a week or two before. Okay. And so we have an offer. This is the indictment.
So you're saying this is a new indictment?
This is a new indictment for Mr. Guzman, which alleges an offense. I believe it's
Same offense.
it's the same offense, but it's a different offense. I mean, it's the same charge, but it's a different offense, different complainant, takes place on a different date, which precedes the one that this will be going to trial. Now, they have given us an offer today, which is a global offer, which involves both indictments, which makes sense. And it's not a terrible offer, but we cannot communicate intelligently, confer with our client about that offer until we understand the nature of this other case, because it includes a plea on both cases. That's number one. Secondly, and okay.
Let's wait for.
Oh, excuse
the
me.
interpreter.
So wait.
All right. Oh, your stuff back there.
Step back.
So it's the interpreter.
Okay.
All right, Joel Garcia. Who's the attorney on Joel Garcia?
Michael, go down.
Today is like is today Monday? Yeah. How many people not brought up dress? I don't know. But yeah, I don't know what's going on. Galvan, Camilla Galvan.
Yes, sir.
So y'all will be back here tomorrow at 9:30. The jurors will be ready. Okay.
Okay.
All right, they'll give you a reset form for tomorrow. You can progress to the program before.
Thank you.
All right, and we'll see which case goes first.
Okay, Judge.
All right,
I have one more that's waiting.
all right, who is that?
Matthew Rendon. Okay. About here.
All right, it's Matthew Rendon.
Yes,
And it's related to Mariano?
yes.
All right, Matthew Rendon. All right, we're gonna bring you back tomorrow for trial.
Okay.
All right, and we'll see which one goes.
Okay.
Okay, they're like two ahead of you. So if you'll get your reset form and then your excuse.
Okay, thank you, Judge.
All right, thank you for your appropriate report. Oh, and counsel, each one of these cases, have you all completed the acknowledgement of discovery?
I think so, Judge. You talking about both these two clients?
Yes.
I'm almost sure that I have that. I'll double check.
All right, if you can double check on that, and if there are any discovery issues, now's the time to let the court know. On Rendon, I see it in the file.
Okay.
The acknowledgement. And there has not been any updates on the discovery.
Not that I'm aware of.
Because one is from May, and that's on, Galvon.
No, there hasn't been any noise.
No, we went back and forth quite a bit in the beginning, and I think we got everything we needed, judges.
And then Rendon is from October.
Of this year?
Yes.
Yes, yeah, we're good on both.
All right. All right, and then Christopher Lee Gonzalez is coming back tomorrow. And if you could make sure he's here. He did, that's so true. Oh, he did?
Yeah, they took him over to CC 14.
Oh, let me have that back.
They'll TIC his felony and plea on the ship.
So do you know if he's already taken the plea in that quarter?
I don't know if he's already taken it, but he went back.
Yeah, he was taking more.
Yeah.
Your Honor, as soon as I get confirmation that plea is finished, I'll have it dismissed for his evading.
All right, thank you.
And Judge, quick question, are my cases in the order in which you called them?
Yes.
Okay.
Well, let me double check.
I know Matthew has sort of a co-defendant, so that makes any difference.
So here's my question. Do you know on Galvon, is the state, do you know which case the state is requesting to plead on first, or I mean to proceed on first?
I do not, Judge. I know Megan's fairly new to it, so we haven't discussed that issue.
All right, so if y'all can discuss that, then I'll be able to let you.
Okay.
All right. Well, that's your client?
Yes.
See it?
Judge,
Yes.
approach. We've come to an agreement, Judge. I just need to talk to Mr. Garrett, handle one last minute thing. We'll turn the paperwork in. All the paperwork signed except for one little stipulation we made.
Okay.
You're telling me the assault, Judge, I'm sorry, Mr. Balvon, they're telling me the assault is probably,
Assault?
yes.
It's the act of servant and it lasts 4 or 7 days.
All right, thank you. Just so both of you are on the same page. All right, and who is here on Christopher Morrison? And where's Mr. Morrison?
Sure.
If he'll come forward. So I'm gonna bring y'all back tomorrow at 9:30. You're not the first one up. There are a couple of cases that are before you. Can you all check to make sure that you completed the acknowledgement of discovery? I don't see it in reports file.
Yeah, and we did file a notice to the court, Your Honor, that they haven't designated their experts. That's the only discovery issue that we're aware of at this point. We've let them know that also,
Okay. Is there anything else?
nothing else.
Thanks for addressing the appropriate report. We always do though.
Oh,
But
thank
if
you.
If you will, make sure you get a reset form from the coordinator, and if you all will double check on that acknowledgement of discovery. See our Mariano Rendon?
Here you go.
Which one?
The one with the first one is the aggravated assault with serious bodily injury, Your Honor. When I had talked to the state, we have a different prosecutor now, but when I talked to the state, it was, we had agreed to go on that case, on the one with the serious bodily injury. Because it was the most serious case.
All right, you have all of the discovery?
I do, Your Honor.
All right, make sure that I have an acknowledgement of discovery because there's not one in either file.
I thought we did one, but I'll make sure we get it done.
All right, so I'm gonna have you all come back tomorrow.
Yeah.
You're not number one. There are other cases that are before you.
Yes, Your
And
Honor.
we'll see what happens. Thank you for dressing appropriately before.
Yes, Your Honor. Would you like me to do that acknowledgement today, right now?
Yes.
Yes.
It hasn't already been done. And
Okay.
then she'll give you a reset, all right?
Should I check the file or have you already checked the file? Should I check the
I
file?
checked it.
Okay, so I'll do a new one. Thank you, Jeff.
Thank you. There you go. You're welcome. All right, who's here on Juan Rios? Juan Carlos Rios, who's the attorney?
Right here, Your Honor.
All right, I'm gonna ask you the same question that I asked everyone else. Has an acknowledgement of discovery been done, because I don't have it in the court's file?
I have signed a few of them at this point,
All right, so has there been any new discovery?
not to my knowledge.
All right, so you can make sure that the acknowledgement of discovery, the state actually has it and the court has it, because it's not in the court's file. And Odyssey is doing things on its own. So I'm gonna have y'all come back tomorrow. You're not number one on the docket.
Okay.
There are a couple of cases that are ahead of you, so those cases may end up going before yours. We'll just see where we are, okay?
That's correct.
Respectfully, Your Honor, Mr. Rios always appears, always waits all day. This is impacting his employment. We would ask that if we're not likely to be called tomorrow, that we be released. Additionally, I have experts for this trial that we have attempted to bring in, but we never know, and because the case is older now, when we should bring those experts in. So I'm gonna have to approach the court and request additional funds for those experts if we're reset. So I would ask the court either to give us some preference tomorrow for trial, or if we can't do that, to release Mr. Rios so that he can go to work.
All right, be here exactly at 9:30, okay?
Okay, yes.
All right, I'll supposed to be here exactly at 9:30.
You understand? Now, Your Honor, respectfully, every time we come to court, we lose an entire day of work ourselves too. This is not typical of most of the courts in this county.
Oh, yeah, it is very typical.
It's not.
Yes, it is.
You can say that, Judge, but I practice on
And
the
say that,
courts.
and it very is typical, because every attorney that's here has a case that's set for jury trial. And this is what ends up happening. What ends up happening is I will allow people to go to civil cases to be out of county, and then their client is sitting here waiting for them. And for some reason, that's the court's fault. That's not the court's fault when attorneys are not showing up at 9 or whatever, and then they stroll in at 9:30 or 9:45. So what I'm telling you all, 9:30, see y'all at 9:30. Thank you. Coordinator will give you a reset form.
Understood, Your
All
Honor.
right,
I'm
thank
trying to make
you.
a record. I don't see the court reporter typing.
What?
Okay, so we only take a record in this court when the judge tells you to? The case was called.
No, the case wasn't called. When I call the case, I call it by the style of the case.
Okay.
All right? All right, so I'll see y'all at 9:30.
Judge, I have to ask you, is this a tactic on the court's part to attempt to wear out the defendant so they can't access their right to trial?
Oh. I find that very inappropriate to say when there is no proof and people are just throwing things out. Now, what I can tell you, and I'm sure your client is aware, sometimes when we end up coming to court, we come to court because there are discovery issues. Sometimes when you're in court, you are in court because your attorney is late. And when I say late, I mean that when a case is scheduled in this court and it's scheduled for 9 a.m. and attorneys go to different courts because they want to go to different courts first, it is not the court's fault that you're sitting here for 12 o'clock or 1:30 or coming back over break. Number one, I have a lunch break. And there was a point in time where I would not take a lunch break. And the reason why I wouldn't take a lunch break is because I said, you know what?
Make a record?
I've been a defense attorney. And when I was a defense attorney, what I would always do, I'm like, I have to be in like 5 courts. It would be nice if they could stagger their docket. And so sometimes I would be here, we wouldn't have a lunch break, and I would be here till 3 o'clock. And then you know what I discovered? When I would say that I'm gonna be here till 3 o'clock, I'm working through lunch, other attorneys, you know what they would end up doing? Then they wouldn't show up in the morning. They would just show up at 1:30 or whatever, because they're like, oh, the judge is gonna stay there. So I stopped doing that because I need a lunch break. And that's what happens.
So then my other question, I guess, is if you're not doing this to cause the hardship, it obviously causes on all the attorneys and the defendants. Are you doing this for the YouTube? Because we don't have a record, right? Except for the YouTube.
Yes, here's the thing. You're to be back tomorrow at 9:30. You
Yes.
understand?
Yes.
All right, thank you so much. And once you sign the reset form, you'll be here tomorrow. If somebody goes before you, somebody goes before you. Your counsel is well aware, or should be well aware, if he's been practicing in Bear County,
For almost
that
20
there
years.
are a lot of cases that are on the docket for jury trial. So for example, I had approximately 40 cases down for jury trial today. And what ends up happening, sometimes people who are in custody take precedent because their cases are
I'm
older than
asking
yours.
for a record, by the way.
You understand? Because they're older than yours. So that's what happens. So then what
Rulings
ends
are
up
being made, there
happening,
should be a record, right?
excuse me, stop interrupting me.
Well, we're not on the
Stop
record.
interrupting me.
right? I mean, we're not in
Stop
court. There's no record.
interrupting me.
Sir, here's your reset form at 9:30.
So what ends up happening, sir, is that people who are in custody, sometimes their cases take precedent. And the reason why it takes precedent is because their cases are older and because the jail is overcrowded. Now, as you may or may not be aware, I call the docket all the time at 9 a.m. And sometimes when I call the docket at 9 a.m., defense attorneys are not here. Your attorney knows when he has not been here at 9 a.m. and then you have to wait. And you
Judge,
need
you're
to
aware
be
that every
here,
court starts at 9.
and you need to
I
be
have other
here,
cases.
and you need to be here at 9. So when your attorney is somewhere at another court, you know what ends up happening? Your attorney has made the choice to have you sit here and go to another court before
Well,
coming
that's not
here.
exactly true,
You
because all of
understand?
those courts got
All right,
business
good luck to
accomplished.
you.
All
Thank
of us
you.
got
Thank you,
recalled
sir.
today,
Thank you,
right,
sir.
Judge? So I mean, what did we accomplish?
Have a nice
today?
afternoon, sir.
I mean, that's the reason I don't come to your court at 9, because I know in another court,
Sir,
something's
here's your
gonna actually occur.
Sir,
And they're courts of exactly the same
Sir.
jurisdiction.
right this way, sir.
Yes. All right, thank you. Hi. All right, Mr. Guzman.
Yes.
All right, so before the interpreter came, and correct me if I'm wrong, your attorneys came forward to let me know that they just received a new indictment. Is that correct?
Yes, Your Honor.
All right, and so that indictment, excuse me. Step away.
I was doing what the court ordered me to do, and checking on the discovery.
All right, so what ended up happening is your attorneys. All right. Boy, things have really changed the way people treat people, which I find very odd. All right, so anyway, the state gave your attorneys an indictment. Your attorneys told me that they didn't have access to that indictment. You were scheduled for jury trial. In fairness, I should not be putting them to jury trial when they just got a new indictment. Do you understand?
Yes.
All right. So my understanding from your attorneys is that the state has made an offer to them. I'm making an assumption that it's a new offer because it's including this new indictment. So legally, your attorneys have 10 days to prepare for trial once they're given an indictment. So therefore, legally, unless they decide to waive that time, I can't force you to go to trial. So you will not be going to trial today. Do you have any questions?
No.
No.
All right.
Judge,
Yes.
before we get off the record, we do need, so Mr. Leal is not appointed on that new case. The defendant does not have a defense attorney, and so I don't know.
So Mr. Leal, are you okay with being appointed on that case because you're already on the other case?
That's fine. And I'm familiar with my client and his situation. So that would be fine.
All right, so if you can make sure that he's appointed, all right. So you'll be appointed on both of those cases. So then the question is, how much time you need? I know the holidays are coming up. So I could call you back in exactly 10 days, but I don't think anybody would want to come back in exactly 10 days.
Late January.
Okay, let me see here. And so what this date will be then, this date will be the plea deadline date. And then after this date, you'll get a jury trial date, but it's going to be a quick turnaround for a jury trial date because we've had some discovery issues with the
Phone calls.
yes. So what we'll do is we're going to put it for I can do January 27th, the 28th, or 30th.
May I check with my?
Yes.
And Yara, you have that new indictment? I think you took it on.
I want to say I thought I gave it back to you all. Did I? Ah, here we are. Is this it?
Yes. Thank you.
You're welcome.
24.
I'm actually
464.
second chair on this case. Did you appoint me second chair on the other case?
Let me see. The file on this, oh, here's the piece of file. All right, so on Guzman, he's gonna come back on the 30th. All right, sir, do you have any questions?
No, everything is good.
All right, we'll see you back then on January 30th. All right, thank you.
Just get a clip of that.
Excuse your honor.
Yes, thank you so much. Yeah. Yes. All right, thank you. Yes, sure. There you are. Yes,
I was being excused for the court.
yes.
I'll go ahead and do that.
And then. Let me get a call. You just get it.
Okay, Mr. Gonzalez. And then I'll return the file.
After resolving my 2 trial cases in here, am I free to go?
You are free to go.
Judge O'Connell reset my case. Judge Torrestal to hear in February.
Oh, well, tell him I said I appreciate that.
Yes. He was happy to accommodate you. He's like, of course, stay there.
Oh,
Okay. Thank you, Judge.
all right. Have a good one.
I'm told the volume on the YouTube turned off at 3:03 p.m. Can't say, but FYI.
That's not me. I'll be glad when we get new computer equipment. See, each time you come down here, I can request things. You're welcome. Mr. Stenberg? Joe? Hi. I already signed the dismissal. I signed the dismissal.
Yes, I gave him a copy and he is so happy.
Okay.
And I take back some of the things I told you about Judge Boyd. Well, not all, but some.
Yeah, you should.
Oh.
He will. So I just made myself a note
Mm-hmm.
of how I follow the form of court on it.
Mm-hmm.
And case on record, and the state agrees with the record, which is wanting a record. It has to be eligible.
Well, there was nothing
I'm just.
for the record.
I know, well, exactly. I mean, in civil court, everything gets beat down, right?
Mm-hmm.
It's not the same. Just thought I better make it it's fresh in my mind.
Yeah.
So I have no idea.
Mm-hmm.
He'll file something just to file.
And I've never had a complaint. They're here. That one? Okay. System.
Is that wrong?
Yes. Oh,
It's got the salary.
sure.
Thank you.
Never she's ready.
Richard Campos? Yes. Oh, yes. Oh,
I think we're coming back at not 1:30, 9:30 tomorrow.
yes.
Okay.
All right. And could you make sure, because I don't see it in the file, the
I'll
acknowledgement of
double check. I
status.
think I did it the last sitting, Judge, but I'll double check it.
All right, and there are a couple of people that are ahead of you.
Okay.
So we should know no later than probably like 10.
We'll be here.
All right, thank
Okay,
you.
Thank you.
And
Yeah.
this. That came loose, so you probably want to restate.
All right, thank you. All right, you too.
I added it to it. Sir, your honor.
Yes.
Name down the way and I excuse.
Yes.
Thank you. Or do you want to- Sir.
All right, that's coming back tomorrow.
Sir. Discovery call.
Oh, let me see what he did. Okay. Yeah.
I'll check.
Yeah. I'm running to the restroom real quickly.
You know what? I don't have the case number. Okay.
Star. 0088.
And Judge FYI, an update on Miss Cooper.
Mhm.
She has an immigration attorney through St. Mary's Law Clinic.
Okay, yes.
And I actually reached out to Stephanie Stevens, who's trying to get me in touch because she's just been approved for a certain kind of special visa. new
Yes.
Visa, which maybe change the landscape a little bit,
Mhm.
but I don't know how everything impacts her. So
So what are you requesting?
I guess I'm requesting a little bit of time, if I could, to consult with whoever it is to see, because the U visa just was approved like in the last, very recent. And she also is remanded without bond on the deferred, but I haven't confirmed with the state on that, but they have a thought on it.
Okay. So where's it coming back tomorrow? Okay, this is, why do I have Christopher Andrade?
We're gonna revoke. That's,
Oh.
I'm
Okay,
doing, I'm doing a bunch.
all right, could I see on, what's your client's, Sherry,
Cooper.
could I see the file on Sherry Cooper?
So this-
I think I filled this out last time, but I didn't.
Okay.
All right, Miss Cooper, if you can come down. Yes,
9.
9:30.
9:30, right?
yes. And I'm putting it at 9:30 because I think sometimes jurors are a little bit late. All right. So you were saying the U visa that's been completed and you need time to speak with the immigration attorney?
Yes, yes, yes. I mean, I believe we're close to a resolution here, but we have some questions that I'm just not capable of answering. Or resolution before.
Right. Miss Abrams,
Yes, sir.
do you want to call this back on I can do the December 16th, 17th, or 19th?
I know this, I personally cannot do the 16th,
Okay.
so, but, we definitely do the 17th and 18th, they're both pretty stacked for me, so I don't, either one is fine.
Well, do you-
Probably the 18th.
No, I said the 16th, the 17th. I'm sorry, maybe I misspoke, or the 19th.
Oh, of December?
Yes.
Okay, well then let's do the 17th.
All right.
But I am pretty stacked that day, but.
Well, wait, we're here.
Okay,
My hours are 9 to 12, sometimes 12:30, and then we come back at 1:30.
people like to eat lunch.
Yes,
Oh,
all right,
17.
yes.
And we're asking the court to consider setting a bond on the deferred. Case.
All right, well, is the state prepared to proceed on a bond hearing for that, or do you need another date for that to be heard, state?
Right now.
Okay.
What was said before.
All right, so what I can tell you all is that on January 19th, I believe, no, November 19th, 2024. I think it was, let me see. Yes, she didn't appear for court. So with that being said, are you all, so that everybody knows what's going on? All right, court is calling 2022 CR 0067B State versus Sherry Victoria Cooper. Can I have parties announced for the record for the state? Defense?
Lorraine Efron.
All right, and are you Miss Cooper? All right, you're here requesting an oral motion for a bond to be set?
Yes, ma'am.
All right, any objection to the motion being oral?
Nothing to say about it.
All right, so you're entitled to a bond. Is there a proposed agreement for a bond?
There is not, Your Honor.
State, what would you be requesting?
Just to take judicial notice of the fact that previous bond in this case was set at $20,000. When it initially came before the court, the state would be requesting a $40,000 bond.
All right, defense.
I think her hope of making bond would probably be if the court would consider a $5,000 or $10,000 bond.
All right, so let me explain to you part of my issues. Part of my issues are, I understand that sometimes when there's a motion to revoke file, automatically, if it's deferred, automatically there's no bond set until the person turns themselves in and they get a bond. But in your case, you left court and didn't return because we had a contested hearing schedule. So what ends up happening is the contested hearing was set and she left and didn't return to court. So I'm not inclined to do $5,000 because part of things for the court considering, your attorney will tell you in setting a bond is whether or not you appear. Because that's all a bond is supposed to be. It's supposed to be to protect society and make sure that the bond is high enough where you're invested and you will appear. And so since your last bond was higher than $5,000 or $10,000 and you didn't appear, I don't feel comfortable setting it at that amount. So what I'll do is I'll set your bond at $30,000. And we are coming back on December 17th. And Ms. Ferguson, if you can give her a December 17th court date. Any conditions that are being requested, state?
GPS, right?
All right. I'll do GPS and waive fees.
Thank you, ma'am.
And can you raise your right hand for me, please?
Yes, ma'am.
Do you solemnly swear and affirm the testimony you give will be the truth and nothing but the truth? So help you God?
I solemnly swear.
All right, you can lower your hand, state your name for the record.
Sherry Cooper, Sherry Victoria Cooper.
All right, do you have a place to live?
Yes,
The place you have to live, does it have a landline phone?
one can be installed.
All right, the reason why I ask that sometimes with GPS,
Yeah.
you need a landline. If you don't have a landline, you're just gonna be waiting at the jail till you get one. And counsel, if there's an issue with that, just come back to the court.
Okay.
Or either you can text me and include Mr. Garahan in the text. And then the other.
Okay, that's fine. I have.
And are you employed?
I was a freelance, like I just got my U visa, my U-1, which I finally got my employment document, so work authorization card.
All right, so
Everything that I do is employed.
so it'll be partial GPS for employment. Are there any drug or alcohol issues?
I have had alcohol, drug issues in the past, yes, ma'am.
All right, so I'll do 60 sober meetings.
Okay.
In 60 days.
Yes, ma'am.
All right, so you know when you're supposed to come back here, make sure you show up, you understand?
Yes, ma'am.
All right, is there anything else?
Thank you, God bless.
All right, thank you. Oh, God bless you too.
You're going back.
We want to know what happened.
Appreciate it.
No, she's. She's afraid that I'm messing up.
Oh, do you have something for me to fill out for her? I need,
I just,
I
know nothing.
Lorraine, if you can write something down, because they need to put it in the system, what I ordered.
Okay,
I need an order.
okay,
All right, thank you.
okay.
Yes. Aldo? Court is calling 2024 CR 02. Court is calling 2024 CR 0622. State of Texas versus Aldo Salas. Can I have parties announced for the record for the state?
Jason, get your head to the state, Your Honor.
Defense?
Paul Goki, we're ready in the plea, Your Honor.
And are you Mr. Salas?
Yes, ma'am.
All right, the court will note for the record that the court has an acknowledgement of discovery that was signed on December 10th, 2024. Court will find that the state is in compliance with discovery. Mrs. Salas, did you review the application for deferred adjudication or community supervision with your attorney? Did you understand it and sign it?
Yes, ma'am.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
We do.
State, are you proceeding on the indictment as presented?
Waiving count 2, proceeding on count 1 and the repeated.
All right. Did you review the court admonishments and defendants waivers with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
All right. You're charged with unlawfully carrying a weapon with a felony conviction. Normally, the range of punishment for that is 2 to 20 years. If the state is able to prove the repeat enhancement allegation, then that will mean your range of punishment will be anywhere from 5 to 99 years or life in prison and up to a $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses? The state will call in the right to remain silent.
Yes, ma'am.
Did you understand by entering this plea, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Did you understand that the court would grant your application for deferred adjudication? If for any reason your deferred adjudication were revoked, the court could find you guilty and the court could sentence you up to life in prison and up to a $10,000 fine. Did you understand?
Yes.
Counsel, has your client been able to provide you with any defenses?
He has been.
Do you believe he has a rational as well as a factual understanding of the charges against him?
That's my opinion.
Do you believe he's currently competent and was legally sane at the time of the offense?
That's my opinion as well.
Sir, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, the state is proceeding on count 2. You're to agree that you've been previously convicted of a felony for purposes of enhancement. There's a $2,000 fine. There's an affirmative finding of a deadly weapon or an offense not eligible for judge-ordered community supervision. The state recommends deferred adjudication. The state will take in consideration County Court Cause number 717682. Did you understand that to be the plea?
Yes, ma'am.
Defense, is that the plea?
It is, Your Honor.
State, is that the plea?
It is, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it? Did you sign it? In both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
Say again, ma'am?
Have there been any such motions?
No, ma'am. No, ma'am.
All right. Outside the agreement, the state is recommending that your community supervision be for a term of 10 years. There be a TAP evaluation and 250 hours of community service restitution. Did you understand those are recommendations from the state and the court does not have to follow those recommendations? Did you understand?
Yes, ma'am.
All right, let's go off the record for a moment. Okay.
And.
Yeah.
Make sure it's right there, and if you don't mind to get your clients also, please.
Yeah. Here, right there, put your initials. They're taking that deadly weapon. Fine. That makes you ineligible. Sorry, I missed that.
No problem. All right, so we're back on the record. So according to your plea bargain agreement, there's not an affirmative finding of deadly weapon. So did you understand all of that?
Yes, ma'am.
All right, then to the offense in count 1, how do you plead? Guilty, not guilty, or no contest?
No contest.
And to the repeat offender enhancement allegation, true or not true?
True.
State any evidence? Any objection?
No objection, ma'am.
State, you may be excused. Did you review the waiver and consent to stipulation of testimony and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied for deferred adjudication. The court will find the enhancement true based upon your plea of true and based upon states exhibits 1 and attachments. Are you proceeding with sentencing?
Yes, ma'am.
All right, anything you wish to say on behalf of your client?
Not at this time, Your Honor. I understand that the court may order a PSI.
I don't need a PSI.
Okay,
unless
he
you-
is a father, Your Honor.
Mhm.
And he is anxious to get back and be a father to his children and will be on his best behavior. He's going to have a problem doing community service and catching up, with taking care of his children and helping with the family. That's why I ask you to not adopt that finding. He also is, for all practical purposes, indigent. I was hired by the family. And if the court would suspend imposition of the fine, it would help him in his rehabilitation.
All right. How many children do you have?
2, ma'am.
And do you live with them?
Right now, no, I've been incarcerated right now about 15 months, but they were living with me before this incident occurred. I'm trying to they're with their mother right now, and she's struggling, so I'm just trying to get back to them as soon as possible.
How far did you go in school?
I got my high school diploma.
What are you planning on doing with the rest of your life as far as employment?
I do carpentry, concrete work, construction. That's what I've been doing for the past 7, 8 years.
Okay.
And I enjoy doing the work that I do, and that's how I've been supporting my kids.
All right, and has there been any drug use in the past?
No, ma'am.
All right, they say you were in the car and there was marijuana.
Yes, ma'am.
So have you done marijuana in the past?
I've done it in the past, but I don't.
No, I'm
use it.
asking.
I've
No,
done
That's
it-
about the
yeah,
past.
Yes, ma'am.
so what else other than marijuana?
Alcohol.
All right, this is what the court is going to do. Court is going to sentence you to 10 years deferred adjudication. Gang supervision, regular reporting by Zoom or in person, regular random UAs, proof of employment within 30 days, no employment as a home health care provider or with minors, $2,000 fine, that will be probated, CPS compliance if applicable, 250 hours of community service restitution, 100 hours will be waived once you've completed parenting classes, 150 would be waived if you obtain some sort of certificate from a trade school. Take in consideration 717-682. There's going to be a TAP evaluation in custody, follow recommendations of TAP. Field visits 1 time per month for 6 months. Probation, is there anything else? All right, is there anything else you need from the court to be successful?
No, ma'am.
All right, did you review the document entitled Trial Court Certification of Defendants' Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, ma'am.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
All right, we can go off the record. In this court, to be successful on probation, communication is key. speak with your probation officer. If you have an issue and you feel like they're not addressing it, you're gonna always come back to the court and address it with me. You're not allowed to own or possess any weapons. Do you understand?
Yes, ma'am.
All right. Good luck to you. They're gonna go over conditions with you.
Thank you, ma'am.
Thank you.
You're welcome. And Bashan, I put in the gang supervision based upon what I read in the police report.
Oh, did you want to read that? Did you want to read over that? You still have that? total?
Never mind. Here you go.
She has it up there. What else?
Did I do the certificate of appeal already?
Oh, she did, sir? Yes, you did. All right, turns up the judge.
I'm trying to.
Oh, she has it up there.
Well,
Sorry,
yeah.
that's the original.
Yeah. Can I itemize an MTR? I'm not itemized here. She's been a lot of work. Oh, she has a new piece. There you go.
And Bashan, on his case, I know if they're doing gang supervision, then you probably won't need the field visits. Are you already on Andrade?
Yes, ma'am. It's like a long-term project. Yes, ma'am. Sure.
All right, court is calling 2024 CR 008840 State of Texas versus Christopher Andrade. Can our parties announce for the record for the state?
Jason Garahan, Your Honor.
Defense.
Lorraine Ephraim for Mr. Andrade.
And are you Mr. Andrade? What happened to your eye?
I got sucker punched by someone coming off drugs.
Okay, do you need me to call over to the jail about that?
No.
Okay. All right, did you review the document entitled Motion to Revoke Community Supervision with your attorney? Did you understand it? Are you the same Christopher Andrade who was placed on community supervision in 2024 CR 008840 for the offense of evading arrest detention with a vehicle on September 27, 2024 for a term of 8 years? Is that you? And counsel, do you waive notice?
Yes.
All right. State, you may proceed.
Thank you, Judge. Violated condition number 39 on or about the 10th day of December 2024 in Bear County, Texas. The defendant Christopher Andrade did then and there failed to comply with the rules and regulation of ethics on report, and that they no longer wish to participate in violation of this condition.
How do you plead to that? True or not true?
True.
All right. Did you understand by pleading true to violation of condition number 39, the court could find it true, grant the motion, and sentence you up to 6 years in the prison and up to well, not a fine, but just 6 years in prison. Did you understand that?
6.
No, that's what I could sentence you up to. All right, did you understand that? Knowing that, do you still wish to plead true to violation of condition number 39? All right, the court will find violation of condition number 39 true. And just so you're aware, the court is aware, based upon conversations with the state and the defense, that your reason for not wanting to participate is not really because you didn't want to participate. It's because you've been sentenced on another case, and regretfully, they didn't continue. If they would continue you, of course, we would have worked with you to make sure that you successfully completed this. So I'm aware of that. So knowing that, is there an agreement?
There is, Your Honor.
And what is the agreement?
It is revocation, Your Honor, and reform the underlying sentence to 2 years and to run concurrent. I don't have the number, but concurrent with the triple parole.
I have the number.
All right. And the agreement that they worked out, are you asking the court to follow that agreement? Are you waiving the right to appeal? All right. So then the court is going to grant the motion. The court will revoke. The court will sentence you to 2 years in the prison, give you credit for any time served, and this will run concurrent with your parole case number.
And cannot find the actual case number on these documents.
All right, if you're able to find that cause number, just let the clerks know and we'll put it in, they'll put it in the system.
Okay, do you happen to know?
And I'll see if I can look it up as well.
Okay,
All right.
yeah, I'll
Did you review the document entitled Trial Court Certification of Defendants' Rights to Appeal with your attorney?
Yes, ma'am.
Did you understand it and sign it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. You understand? All right, and I'll put in the therapeutic community. It doesn't increase the time that you're in custody, but if you want to take advantage of it, and if they give it to you, they'll know that I'm recommending it. All right, we can go off the record. I regret that you won't be able to participate. I think you were prepared to change your life.
I was.
All right, well, once you're released,
Change that.
that's good. Once you're released, if you can't find a place for treatment or something of that nature, if I'm still here, you can come by, I'll call and see where we can place you, okay?
Thank you.
All right, good luck to you. Yes. Yes.
It's not the same person.
Ah, okay, all right.